Good evening, everybody. Welcome to tonight's study session for the City of Casa Grande. You guys are in charge.
Thank you, Mr. Mayor, members of the council. Thank you for the opportunity to come before the mayor and council this evening and present in this study session format information related to Prop 207, the Smart and Safe Arizona Act, the adult use of marijuana. I'm sure that all of you, like many of our residents, understand that on November 3rd, the ballot question received sufficient vote to actually pass. It was approved. Staff is going to provide a overview tonight, a presentation to the mayor and council on a couple of different topics. But before I get started on that, I do want the council to know that we have a corresponding ordinance that staff is proposing to mayor and council, and we'll talk a little more about that here in a bit during our regular council meeting. But our hopes are, while we've got a number of slides we want to go through, that we can engage the mayor and council and get some level of feedback on what we're proposing at this time related to Prop 207, at least from a local regulations perspective. And potentially, if there are some amendments that would need to be made to that ordinance, that staff could spend a little time before we get into the regular meeting talking about those, so that we can ensure that the mayor and council are considering the ordinances as we discuss here this evening. So we've elected as a team to actually break this presentation down into what I consider to be three components. I will give a bit of an overview to the mayor and council about Proposition 207 and really the various provisions that were considered and approved as part of that ballot measure. I will then ask Mr. Paul Tice to speak on the existing zoning as it relates to medical marijuana, and and dispensaries specifically. There are some important provisions within our existing code that I want to refresh the mayor and council's memory on. And then lastly, I'll ask Mr. Brett Wallace to talk a bit about the proposed ordinance and some of the driving factors behind our recommendation this evening. And so, let's just, and I know that the mayor and council has received information related to the proposition, and obviously all of you have likely reviewed that prior to casting the ballot on November the 3rd. But a couple of the provisions that I think that are key for the mayor and council to understand as we move into tonight's presentation is that the approval of Prop 207 essentially allows an individual who is at least 21 years of age to, and I guess I should advance the slides, to possess, consume, purchase, transport, and manufacture 1 ounce or less of marijuana. Moreover, individuals who are 21 years of age and older can grow no more than 6 marijuana plants in a resident, and that number can actually increase to 12 if you have 2 adults that are 21 years of age and older living in the same residence, provided, however, that the plants cannot be viewed or viewable by the public and must be in a secure location. And the proposition does go into a bit of the details of what that secure location actually requires. It allows both an existing medical dispensary or other applicant to seek to become a licensed establishment with the ability to engage in the retail sale, cultivation, and manufacture of marijuana and marijuana products. I want to highlight this particular issue because I think it's important for everybody to understand that the city of Casa Grande does have 1 medical marijuana dispensary in one of our 3 districts that is currently zoned or will allow for the dispensary. Moving on to additional provisions of the proposition, it restricts a local government from enacting rules that are more restrictive for a non-medical establishment than provided for medical establishments, or from restricting a dual license that has both a medical or non-medical license from providing retail sales of non-medical marijuana. We'll talk a little more about that. I think that's important, an important component because we do have a medical marijuana dispensary in town today. The proposition does allow local governments to prohibit adult use marijuana establishments other than dual licenses if they exist. Again, another important component based on our proposed ordinance this evening. And testing facilities from operating within their jurisdiction, as well as restricting delivery of marijuana within the city. So the proposition does give local jurisdictions some authority over the dispensing of recreational or adult use marijuana. And I should have pointed this out earlier. It should be noted that the Arizona Department of Health Services actually controls the permitting of these and the licensing of these dispensaries and establishments. The city of Casa Grande does not have any type of authority in the permitting or licensing process. However, we do have the ability to establish zoning districts for establishments and dispensaries. An existing medical marijuana dispensary license can obtain a dual license to dispense both adult marijuana and medical marijuana as an early applicant beginning January 19th, 2021. A decision on the license must be made by Arizona Department of Health Services within 60 days. I do want the mayor and council to know that there's still what I consider to be a lot of work that has to be done by the Arizona Department of Health Services. The proposition gives some level of guidance through the approval and the statutes that will be established. But Arizona Department of Health Services controls the rules and regulations. They are going through that process now. In fact, staff participated on a stakeholder call last week that really focused on these early, what I would consider to be early applications that actually will, where applicants can begin to make their applications on January the 19th. Arizona Department of Health Services will develop the rules for marijuana establishments. ADHS has established draft rules for initial establishments of these licenses. I emphasize the word draft at this point. The rules the proposed rules that ADHS put out have not been finalized at this point. From the application perspective, have not been finalized at this point. They've allowed for public comment, and as you will hear later on in this presentation, there are other components of the proposition, such as the social equity permits that actually have not had any rules developed at this point in time. They are still working on those. The proposition does not allow the smoking of marijuana in a public place or open space, or the consumption of marijuana products while operating a vehicle.
Larry, how many other distribution points will there be? It has to be at least 2 in Pinal County, I think.
And I'll let Mr. Wallace expand on this, but each county will have up to 2, at a minimum of 2, right, Brett?
Right. The way that the licenses are distributed in the proposition are actually very similar to the way that they're done in the medical field for this. They're limited to 10% of the number of pharmacies. That's how they establish the initial number of licenses. But at least 2 in each county is what the proposition says. We believe we already have 2, meaning that we wouldn't fall under any of those bonus sort of must award licenses. But again, the early applicants, to be an early applicant, as Larry was saying, it really deals with the people that already have medical licenses, or if you're in a county with less than 2.
Coolidge was pretty anxious to get that originally. Are they set up for it, or do we know?
Who was that?
Coolidge?
I'm not sure if Coolidge has one yet or not. If they don't, then they wouldn't be able to do a early applicant.
Okay.
They would have to go through the second round, which is going to be through some random selection.
Just furthering what I consider to be some of the key provisions of the proposition is that it allows for the collection of an excise tax on all marijuana sales to customers. It establishes a smart and safe fund and establishes distribution guidelines of those funding sources, and it establishes the number of allowable licenses based on the number of existing pharmacies, as Mr. Wallace was just pointing out, in Arizona, and subject to adjustment to ensure the opportunity for at least 2 establishments per county. In addition, it will allow for 26 initial social equity licenses to be allocated throughout the state. And so, again, we do not have, outside of what was articulated in the proposition, any information on the social equity licenses. It was abundantly clear in the stakeholder meeting that we had last week that this is something that the department is going to focus on after they go through some level of the early applications. Oh, thank you. Sorry about that, Stephen. I want to talk just briefly, and certainly if there's any questions on the violations, I'll ask Mr. Wallace to weigh in. Most violations of the propositions are initially established as a petty offense, which for the first offense does not allow for jail time and imposes a base fine not to exceed $300. And the proposition provides for pending charges, dismissal of pending charges that would not have violated the proposition, and also provides an expungement of prior convictions. And then lastly, the proposition will change police practices related to probable cause and marijuana DUI, and the state legislature will likely need to act in order to provide clarification on some of these components. And so with those three provisions, I do want the council to understand that organizationally, we obviously are having to deal with the law enforcement component of this. Concurrently, there's still a fair amount of information that is now beginning to come into our department, and I know that Chief McCrory has been reviewing all of that, and we will be going through training for our law enforcement officers that are having to prepare for and actually deal with the passage of the Proposition 207. We also have, from a personnel policy perspective, our drug-free workplace that the city actually utilizes as part of our relationship with our internal employees. The primary focus tonight has really been with an emphasis on zoning and the ordinance that will be proposed in the regular council meeting. But I do want to assure the mayor and council that as information becomes available on those other two topics, we'll be sharing that with the mayor and council. And with that,
Expunging the existing, who does that, the state or the?
So under the terms of the proposition, you kind of have a couple of ways that can happen, but for most of the time, what's going to happen is a defendant will make a motion to have their conviction expunged. And essentially what it does is if you've been convicted of something previously that would not be illegal under the current act, you can ask for that to be expunged. And in fact, it's going to be a fairly rubber stamp process, because as long as it meets that, it will be granted by the courts.
Larry, if I have a question on the actual ordinance when it comes to the violation, should I go ask now, or do you want me to wait during the council meeting?
if it's on the ordinance that's being proposed
Yeah.
tonight, perhaps we can align it with the presentation on the ordinance, which is coming right after the zoning component, okay?
So I guess I'm next, Mr. Mayor, members of council. I'm going to just take a few minutes to refresh your memory on our existing zoning regulations regarding medical marijuana establishments and uses. So the top of this slide shows you, first off, the zone districts in which medical marijuana dispensaries may be located. And although you see a lot of zone districts shown there with the P with the footnote 3, it goes on to say they have to be within the overlay zone. And I'm going to show you a copy of the boundaries of the overlay zone. If you recall, we formatted that overlay zone of the area right around the hospital. The footnote for the 3 indicates that in addition to being an overlay zone, the use has to meet a series of separation requirements from various uses, and I'll refresh your memory on that in just a moment. The next line down is medical marijuana uses, and it says that they are allowed to be in both the I-1 and I-2 zone districts, industrial zone districts, subject to the same separation requirements that the footnote 3 refers to. The definition of medical marijuana uses is important to note that it includes collectively cultivation facilities, a dispensary, and infusion facilities. So it could be cultivation, dispensaries, and infusion. So this graphic shows you the boundaries of the medical marijuana overlay zone that was done around the hospital. In addition, what this graphic shows you is how much land within that overlay zone currently meets all the standards, the separation requirements, to allow additional dispensaries to locate. And as you can see, that's in yellow, and it's a very limited area within this overlay zone that could actually accommodate additional dispensaries if they were allowed to locate in the community. Both those lots that are shown as yellow are actually owned by Banner Health and would have to be re-subdivided so that the entire lot met the separation requirements. The red shows us where the existing Harvest dispensary is located. It's on the north end in a tenant suite in that building. So the next slide shows us a scenario where if the Harvest dispensary wasn't located in its existing location, so let's say, for example, Harvest said we wanted to expand our dispensary due to the increased demand with the adult use as well as medical, maybe get some higher visibility. So if they were to leave their existing facility, it frees up additional land because there's a separation of 500 feet from other dispensaries. And that increases the amount of sites where, for example, Harvest could relocate. But those sites only free up if Harvest were to vacate their current premises. And once a additional dispensary was located on one of those yellow sites, a new buffer would be put in 500 feet around that dispensary, which would probably eliminate all the other sites available. So I think it's kind of fair to say that, you know, you could have one, maybe two at the most dispensaries with our current separation requirements in our medical marijuana overlay zone.
Paul, where would they be growing it, on that same property, or?
The growing,
Yes.
that's a great segue into my next slide,
Okay, I'll be
which
quiet.
really is going to talk about cultivation facilities. So both in the Harvest one today, they do not grow there. It's just a retail dispensary. I don't believe Harvest has any intention to actually combine a grow facility with their retail sales. Grow facilities would be within that definition of the medical marijuana uses. If you remember, the medical marijuana uses are allowed in our industrial 1, I-1, and I-2 zone districts. This map shows you the location citywide of those in the two shades of purple. But when we apply our separation requirements to all those industrial sites, and you can see the separation requirements are listed in A through H there. Once we apply those separation requirements, it further restricts the potential industrial sites that could theoretically accommodate a marijuana use. Today, a medical marijuana use. Depending on how we change the code, it could just be a marijuana use, but it clearly further restricts those sites. Now, we actually have had recently some inquiries to constructing cultivation facilities in Casa Grande. So we've actually had 4, what I'm going to call fairly live proposals. None of these are in the building permit stage, but people have asked us to look at the sites to confirm they met all of the separation requirements. And so we have one up in our industrial airport, in an existing building in our airport industrial park. We have one on VIP. Happens to be a building that right now was can't think of the manufacturing type. It was like a fiberglass manufacturing, I think, and they're tearing down a bunch of the old piping and venting right now with the idea of coming in for interior remodel for that. We had one at the Golden Eagle site, and so that met all the criteria. And then we had our newest one was on Hannah Road, right behind the facility that was the old Tremel Crow building that Lucid is located part of their facility in. So all 4 of those sites meet the requirements for cultivation. because they're industrially zoned, they meet all the separations. But as you know, as a medical marijuana use, in addition to cultivation, they could also have dispensaries by the definition today. And so they haven't asked for dispensaries. Our current code only, our Arizona Department of Health Services regs limit us to one dispensary currently in Casa Grande. So there is no ability, but if that restriction gets lifted by Arizona Department of Health Services, our current zoning code would allow dispensaries as well as cultivation at these location. And it would be cultivation and infusion, like where they can make edibles and food products, edible products as well.
Does cultivation need to be inside a building?
Yes, it does, and it has to be secured, yes.
Was there something in the ordinance about testing facilities?
So testing facilities are kind of new in the new rules for the ADHS, and so a lot of these new dispensaries are going to want the marijuana tested for certain aspects of it. Our current code is silent on where testing facilities could be, and so that's one of the policy decisions I think we're going to have to talk about is do we allow them where in our industrial zones as well, or how do we treat testing facilities? So I think it's time to pass it off to Brett.
Thanks. So I get to talk about the ordinance probably because it's more legal in nature. So I'll be happy to do that, and of course, answer any other questions that anybody has. As you guys probably know, many cities and towns have kind of taken the opportunity over the last couple of months since the passing of the proposition to take a look at how they're going to try to incorporate these uses within their city. Staff's recommendation to you is essentially to start with a ban on the facilities that we can ban, to allow us at a minimum to implement zoning regulations, as Paul was talking about with testing, to kind of take a look at where we can go. And so as we go through this ordinance tonight, if there are things that you don't want to put in, we certainly can amend that, as early as tonight, but understand that we've kind of taken a broad brush here with the idea being, let's stop it for now to the extent that we can, and then back it off if council desires to do that, as we see the ADH rules get in place, and as we see our zoning for things happen as well. And so we'll kind of go through what that is. Primarily, this ordinance is based on the work of the League of Arizona Cities and Towns. We had a group of attorneys that sort of worked through a model ordinance, and I've tried to stay as close to that model as we can because we want all the cities and towns to have as close to common regulations as we can, so we can defend them if necessary in that way. And so just looking at the ordinance real quickly, we start with, we're going to have a lot of things that are going to be in the zoning code. This is not a zoning ordinance right now. This is only in our health and safety code, and it's designed to utilize the provisions of the proposition that said we can do certain things, to say this is the way we're going to regulate the uses generally in our community. And as Paul was talking about, we're going to follow that up with the changes to the zoning code to implement them. So for example, as we get into the dual licensee, Harvest at this point is the only one that could, but if they apply for a dual license, that would be permitted under our ordinance, and I'll talk a little bit more about that. But we really don't have a good zoning for that right now. We would treat it as the medical, but with some of the changes that Paul's group is going to be looking at do we just put in medical and dual licensees, for example, right? And some of those will have to be changed in all of those different things. So we start out with a lot of really exciting definitions. If you guys have any questions on those, let me know. For the most part, they're definitions directly out of the statute. Yes, sir.
Testing facilities, are they is like a DUI, the amount that you have in your system, or what's the testing?
So two separate things. For the testing facilities themselves that are talked about in the proposition, that's actually going to be, since now they're going to be selling marijuana for adult use and edibles, they have certain criteria in there. Like they can have, if you're going to advertise, kind of like the FDA, if you're going to say it has, 37% THC, they want to make sure that they're going to test that and find that that's there. Make sure there's no solvents or anything else that the department rules don't allow. So the testing facilities are going to be akin to a laboratory. And they're going to have to be either the department or someone that the department will license. They haven't put the rules in place yet, and so when we get to that part of the ordinance, you'll see that for now we've said, let's ban those testing facilities, at least until we have time to go through the zoning I think a number of cities are going to look at those as potentially needing, for example, a conditional use permit instead of being being principally permitted. And so those are the things we're going to try to address in the zoning. And then if you wanted to then allow the testing facilities, we'd have the rules in place that would allow us to do so safely. Staff's original thought was not to ban the testing because we figured it was like a laboratory use, similar to what we would have expected in medical marijuana. But in light of the fact that we don't really have the zoning in place for it right now, to avoid any issues, we're kind of asking that we stop that until we get those zoning rules in place. And then the second point to your component has to do with a little bit more of dealing with like DUIs. And I know we got another question of that earlier today. And so it's not addressed in our ordinance, but I certainly a Prop 207 thing, so I'll kind of talk about it. There's not going to be a number, at least yet, that's going to presume that you are impaired if you are under marijuana, under the influence of marijuana. Okay? Today, under DUI, we have a couple of different things, but under 1381A3, we go back about 7 or 8 years ago. If you had any marijuana or its metabolite in its system, and you were driving, you were going to be found guilty of driving under the influence of marijuana. And we do the same thing for other drugs on Schedule I, Schedule II. If you're driving with those in your system, you can't be doing that. The Medical Marijuana Act did a couple of different things. The first thing it did is it established an affirmative defense for a medical patient to say, for example, I had the right to use this, and then they could establish that they were not impaired. This act goes a step further in that says you can't use the metabolites at all as a per se, to say a per se violation of the statute. So what happened is the Supreme Court about 2014, looking at the medical marijuana, there was a case where they had taken blood and they used the inactive metabolite in marijuana, which I think is carboxy-THC, but that inactive metabolite can stay in your system for 28 to 30 days, but it's inactive. And so the Supreme Court said, you can't base a DUI conviction off of that because there's no reason to think that you might be impaired. You could have taken this 3 weeks ago, right? 4 weeks ago. The alcohol is going to be out of your system tomorrow, right? You know, the marijuana is going to be out of your system tomorrow, but the remnant may be there for 28 to 30 days. So currently, if we wanted to prove a A3 violation, the per se drug violation, we'd have to show that you had the active THC in your system. And that's really only going to be somebody who you catch pretty much right after ingesting marijuana. Under this proposition, even if they have the active THC in there, you're still going to have to show that they're impaired to the slightest degree, which is just in our traditional A1, we have to show that, for example, we look at your field sobriety test. You know, how did you do on those, right? What was your driving? How is your speech? All the different things that you look to determine whether a driver is impaired, but there's no per se limit. And if you have any metabolite in, it won't be a per se conviction simply for that. It's going to have to be based on A1. What the proposition does do is it allows, if there becomes a national standard, and the National Highway Transportation Safety Administration adopts a national standard, then Arizona could adopt the same national standard as a per se rule. So for example, Colorado, Washington, I think Montana, Illinois, all use an active number of 5 nanograms of THC. Nevada uses 2. Arizona couldn't use any right now unless it becomes a scientifically accepted thing and NHTSA, NHTSA adopts it. So there won't be any, if you have 4 nanograms, you're okay. You know, if you have 6, you're not. It's just going to be whether we can prove baseline impairment, which will be based on your driving and behavior.
So we should be smoking marijuana now.
So let's talk about that a little bit.
Not on city property.
Yeah,
Right.
exactly.
So one of the first things that we talk about, so first of all, Prop 207 regulates smoking of marijuana. And it says that you cannot smoke marijuana in a public place or an open space. It uses public place the same as the Smoke-Free Arizona Act. And so that kind of covers your restaurants, your airports, you know, bars. You can't smoke marijuana in places that you can't smoke. It's actually a little bit broader than that because even on like the patios, for example, like if you're on the Dell's patio, you can smoke a cigarette, you still can't smoke marijuana. And I use the term smoke because they use the term smoke. There are other ways that you can ingest marijuana that are not stopped by the act in public places or open spaces. So if you're consuming an edible, if you're using a vape pen, there was an Arizona Attorney General's opinion that said that vape pens were not smoking because it doesn't actually ignite the marijuana. So those kind of things would still potentially be legal in public places and open spaces. Honestly, we've gone back and forth on how to address that because at some point, from an enforcement standpoint, it's very difficult. If you don't know if someone's eating M&Ms or if they're taking an edible, and it's very difficult to prove which one you do, even if you can show that they have an edible with them, they're allowed to possess it. And so that's one of those where you just sort of say, what do you really do about it and whether you should ban it at all for the consumption, smoking certainly. But we've taken the position now to ban consumption partially because of vaping, because there's not enough information about vaping. There have been some studies that show that residual cannabis can land on the surfaces and otherwise, which tells you if you're next to someone else, maybe they get it. So while, at least in this first draft, we are banning all consumption in the places that we're allowed to ban it. Okay? We can't ban it in private areas via city council because of the proposition, but we can ban it on areas that we control. Right, property that is owned or controlled by the city. And so what this ordinance does is it bans all of the things that we're allowed to do. So you can't cultivate it on our property, you can't manufacture it, or possess it, smoke it, or consume it. And so if we want to have something lesser than that, we can certainly do that. And again, like everything here, we can also peel it back as time goes on. So that's
How does this affect the cartels?
That's really a good question, right? And not one that fortunately we hopefully have to deal with, and better for Chief McCrory. It is going to be an interesting thing, and we've talked about it a lot in terms of what the market for marijuana is going to look like, because you're going to have more legal ways to purchase it. Those legal ways are going to be subject to taxation and surcharges. There may be some people that don't want to go, through that thing, but at least the last briefings that we had is they're just going to say more meth, right? Less marijuana, more meth, and the cartels will probably be resilient in that. We have seen less, at least from the Border Patrol numbers that I saw recently, fewer marijuana transfers coming in, and that's nationwide, partially because you're growing it here in the United States now much more freely. So, but I don't know any cartel members that I know of, and I haven't asked and don't want to speak to that.
Is growing marijuana without being permission by the state to do it, is that still illegal?
No, in your own home.
So-
you can raise 6
I mean, you can
plants.
take somebody home, but I'm talking about
Right.
some guys would take a cotton field and take the middle of it
Right.
and put
Those-
marijuana there, so from the air, you couldn't tell the difference.
Yeah, so for grow operations, you would have to be licensed, big grow operations, you have to be licensed by the department in order to do those. What the proposition does, though, is it does allow individuals to grow up to 6 plants at their home, and Larry had spoke to that, as long
12
as it's
if you're
in
married,
an
huh?
enclosed, 12 if you have another person over 21 that's at the house. It's a very big change, and it's a very interesting thing, and as the department goes forward with medical marijuana, it'll be interesting too, because you may recall back in 2010, we had a number of conversations about it, and you kind of wanted a dispensary in your community. And the reason you wanted a dispensary is that if you had a dispensary, then no one within 25 miles of that dispensary could grow in their house, right? So they weren't allowed to do that, even though the Medical Marijuana Act allows caregivers to grow. So that's why we don't have any caregivers that are allowed to grow here in Casa Grande, because we have a dispensary, so we don't have that. This proposition now allows everybody with an adult in their home to grow in their home. So it'll be interesting to see how they start to allocate these medical dispensaries in light of the fact that people can just grow on their own now anyway. So the effort you had with kind of these CHAWs and how we're going to allocate these around the state to reduce the amount of home growth is now going to be very interesting. And ADHS is permitting, under their existing rules, medical dispensaries to move from one location to another. And so even though we only have one right now, under ADH rules, there is always the potential of a second medical dispensary locating here in the city as well. And that's when we get to the next part, of the ordinance, which actually bans marijuana establishments except for dual licensees. So what we're doing with this provision of the ordinance is to say, I don't know where it's at in there, but are we on there? Okay, so.
Hey, Brett,
yeah.
before you go to that next section,
Yes.
because I have a question on the one above that, the
Sure.
public property. So, well, first of all, I was happy to see this ordinance, because I think it's kind of a moderate approach. And, you know, I know I've been reading on what some of the other cities are doing, Scottsdale and Gilbert, and something very similar. So I'm really happy to see that, you know, we're just a little conservative and just kind of see where it's gonna go and what we need to do. So doing the dual license is a good idea starting out. But my question is the violation piece. So I understand that we ban, you know, and especially the number one, you know, where it talks about possess, smoke, consume, sell, and distribute. And then when you talk at the violation, it says A1, it's a misdemeanor, and the others are a petty offense. So I guess my only concern is, you know, I get on public property if they're selling and distributing, consuming, but if they're possessing and smoking, should it still be a misdemeanor? That was my only thing, is looking at that misdemeanor versus the petty offense.
Absolutely, and I think it's a good question. I actually spent a lot of time with my prosecutors today talking about that kind of same thing, partially because we have a little bit of a typo. We meant to say a Class 2 misdemeanor, so I'm glad you actually brought it up, because it's a typographical error. The reason that we used a Class 2 misdemeanor is that it's very similar to what we do, for example, if you have open alcohol containers on city property. And we went back and forth in the drafting of this, and I'm open to do either one, of dealing with possess, smoke, or consume as just a petty offense, similar to what it would be anywhere else. Cultivate, manufacture, if you
Right.
start using our parts to try to
Selling it or
manufacture
whatever.
or sell, right, then we want to make sure that that has a little bit stiffer penalty. But I completely agree, and the penalty is ultimately up to you guys. We can change that piece to probably move possess, smoke, or consume and make that a petty offense. In fact, we spoke about that today. The other ones, we are recommending a Class 2, simply because it's going to be a more serious violation, like you're growing at our golf course, right? So, as opposed to simply having some, you know, when you walk onto City Hall campus.
Well, I mean, you want it to be serious, but then, you know, you don't want someone to go through that process of having a,
But it's
you know,
legal, too.
misdemeanor.
I mean,
Pardon me?
But it's legal to possess,
Right,
you know.
exactly, and smoke.
will be, yeah.
And, you know, everything else. So I don't know, I don't know how anyone else feels, but that was my only thing, is having a
Well,
misdemeanor.
It's a
Yeah.
good point, and then the rules that we have to realize have to be enforced.
Exactly.
And so
Right.
are we making that more difficult by something like Matt said, that it's gonna be?
Right.
Yeah, and I think, I appreciate the question, and it was something that we were already looking at, you know, and I think it does make a lot of sense to deal with possess, smoke, or consume solely as a petty offense, much like you would do anywhere else. But the other ones, I'd recommend you still have a Class 2, even a Class 2 misdemeanor is a relatively minor offense, but I think the intent of the proposition was to try to decriminalize as much as possible
Exactly,
basic
yeah.
possession and consumption.
Right.
So it's a great
Okay.
question. So on the marijuana establishments, we are prohibiting standalone establishments at this time through this ordinance. That's something that the ordinance, the proposition allows us to do, and at this point, what we're doing is prohibiting them unless they are with a dual licensee that is in the same location and is maintaining its medical license. So at this point, we have only one of those, which would mean Harvest would be, if they proceeded to get a license, a dual license, they would be permitted, but no one else who's not a medical dispensary could locate here. As Paul showed you, there are still a number of places that a medical dispensary could potentially locate here if they were licensed by ADHS or moved from a different location to do that. We haven't heard of anyone trying to do that at this point, but I just want to make sure everyone understands it's a possibility. When you look at most of the ordinances that the cities have passed, you see the papers saying we're limiting it to one, but none of the ordinances actually do that. They limit it to dual licensees, and they currently only have one. And, you know, so there's always the possibility of another medical coming in which would allow you to have another potential retail. So your options really on this are, you can allow retail standalone establishments, and if you did that, you could limit the number of standalone establishments, or you can prohibit them, but we don't prohibit dual licensees because the statute says we can't. I've seen one city say they're both prohibited, but that's because they don't have any medical at this point, and so they think that they can do that. I'm not sure that if they have a medical transfer in there, since they allow for medical, they'll be successful with that. But again, I think right now, most cities and towns are trying to maintain their status quo until such time as, you really get a sense from their council and the community what you might want, and also deal with it from a zoning perspective to make sure that any facilities are located in an area that you would feel comfortable with. So except for dual licensees, we prohibit marijuana establishments. We also prohibit marijuana testing for the same reason until such time. And staff was originally going to not put this in, but since we don't have the zoning regulations in, we didn't want to see these pop up, or at least try to pop up in places that we don't think are appropriate.
So realistically, when you say we can, wait and see, once zoning, I mean, what, are we saying we'll look at it in a year, or you look at it in a couple of years? It can kind of depend on maybe
I
leagues
think
of
it's going
cities
to
and
depend on
towns?
what the state comes up with, right?
I think,
Yeah.
Right.
look, you have the opportunity to look, Councilmember Fitzgibbons, at it at any time. Right now, I think staff's position was, let's take the most conservative approach we can, at least until we work on some of our zoning, to make sure that we don't have any ambiguity in our zoning, because right now we don't expressly address the retail sale of marijuana. Because it's retail oriented, because it is a sale of that, Paul would probably try to say, I think it should only be places where the medical dispensaries are, because that's the closest thing to that we have. But an applicant should say, I'm no different than any other retail. You tax me like retail, so I want to be at the promenade, or I want to be across the street from City Hall. And we want to make sure that if our community wants that, we go through zoning and make sure that it's only in places that we feel comfortable. If we feel comfortable allowing standalone establishments in a business or commercial zone, that's okay. And we can always repeal these provisions that ban that.
Right.
But once they're here, you can't stop that. You can't take those rights away from them. So we really have to do it now or never. But you can always pull this back. We'll be evaluating it. We'll all be going through this process constantly. It's going to be a continuous program as we look at what happens here and throughout the rest of the state. So whenever you're ready to make a change, for example, if we get the zoning in, we may want to bring back at least the testing part and say, hey, we think we're comfortable with zoning for testing. Do you want to allow that? Do you not want to allow that? Because we can back off on any parts of this ordinance at any time.
Hey, Brad, I think the best way it was described to me too is that we need to take this action now because we don't really know all the rules yet. So we take it now before it's enacted, then we can back off. Because I don't think we should allow a monopoly either, right? Just one location. So that was my biggest concern. But
Start in first grade, huh?
as it was described to me, we can, once we see the rules, because right now we don't know all the rules. And once we see the rules, we can then back off of what we're doing tonight. Go ahead, Matt.
One thing is, we don't want to miss an opportunity either. I don't know how much tax dollars this is, but Brett, is the January 19th, is that only for existing medical to apply? So we don't know how many we could possibly have here?
Right. So just from a timing perspective, and it's a good question and response I was going to give to the mayor's point as well. The January 19th through March 9th period is only for early applicants. And early applicants under the proposition are those holding existing medical licenses and kind of what I'll call bonus establishments if your county doesn't have at least two.
And
So-
do we know?
We think
Yeah,
we
the county
do.
does.
We think there's some in AJ that qualify, in Santan, but we are trying to find that out. ADHS didn't know that answer on Thursday in our call. They knew that, 7 counties, I think, 7 or 8 counties only have one, but it looks like those are mostly outlying counties. So those are the only early applicants. So this first process from January 19th through March 9th, only early applicants can get those.
So really,
this
we're
isn't-
dealing with one. in
We're only going to be
Casa
dealing with one, unless we get a transfer of a medical one in the next few days, but there's really nothing that's pending. We haven't gotten any zoning applications, as Mr. Tice said, for dispensaries. So we're really looking at only one during the early application period. After the early application period, however many licenses have not been distributed will then be available in a second round, and that will be via random selection.
Like the first time around.
And we'll have a better idea of when that is as ADHS finishes their rules. So you may, if you want to allow for those locations, you know, a few months from now, it would be March, April, May, June, we may want to back this off by then, but that also gives Mr. Tice and his group time to put in some of those zoning regulations so that when we do back that off, we understand what those regulations are. Some may be very simple. We may just change recreational from marijuana, you know, from medical, but that would allow sort of an unlimited number in our industrial zones. So that's what we're going to look at, and both your planning commission, our public, and you will obviously get to see all of those zoning ones. And at that time, if you do want to allow additional areas, you have the opportunity to do that, even if it's a standalone.
Because no matter what we feel about it or anyone feels about it, it's legal now. You know, just like alcohol, some people don't agree with that, and I think we're gonna be treating it more like that, because we don't wanna miss opportunities, and you gotta look at it too from a business. I'm sure you guys have been called from realtors too, like, hey, there's not a lot of places in our existing zone, and people are beating down the door. I think it's gonna be very limited, though, how many, I don't think there'll be 10, because I don't think there'll be that many licenses, but we won't know. But I wanna make sure that we don't miss any opportunities either by doing this. But like you said, we won't know our number until March-ish, but we can undo it or change it pretty quick. And I don't know if you guys, before this, since we're doing this, you know, I drove by a bunch. You can't go in them unless you're a patient now, right? And they're all nice-looking places. You know, it's not like there's lines of people out front hanging. I mean, they're all nice-looking retail establishments, and you know, I think that's a big fear that people have. But when we were up there this weekend, I thought, well, you know, there's billboards, so you know where they are, and it's pretty simple to find. But it's something to think about, is people have this impression of it, you know, and it may not, but that's what we would come to down the road, because again, I don't want people, and now that we have this ordinance, I'm sure people will say, hey, I think this would be a good place for one, and then we could get a feel for the community and what they think in that area, if they think that's a good place.
Yeah, so again, you have either option. The ordinance as drafted right now would not allow those standalone establishments, but as I said, and as you just pointed out, we can always pull that back after you've kind of dealt with it from a zoning perspective. And the zoning, we think, is really a useful tool, because they do a good job of getting out in the community. The industry will be paying attention to what you're doing from a zoning perspective as well. And, you know, there's multiple opportunities for public input throughout the zoning process.
The existing place right now that's out by the hospital, if we decided we just wanted that to do medical and recreation, period, and no one else involved, can we do that, or does that have to?
So I'm going to answer, it depends, because that's my favorite answer. But effectively, you're doing that now if you adopt this ordinance. But I say that because under ADHS rules, an existing medical dispensary could still locate in the city. And I don't believe under the proposition, we can limit it to one dual licensee. And I say that because if another medical came and wanted to go in one of those areas that Mr. Tice showed you, that would be allowed today. And once they're here as a medical, they would be allowed to get a license as a dual licensee. So your actions tonight would effectively limit it to the one existing medical dispensary for the time being. But if we have a second medical locate, we would not be able to prohibit them from also being a dual licensee. We have no reason to believe that's happening right now, but I want to have that caveat, because if I don't, they'll come in like in 30 days and it'll look bad for me.
I do have a question for Paul. Paul, Because at one point in time, I had the understanding that it couldn't locate, or medical marijuana couldn't locate in the airport industrial park.
We have a separation from the airport itself, but not a prohibition within the airport industrial park. It's on a piece of property that's not owned by us. It's an existing building privately owned. So we have a separation from the airport, and it meets that. If you look at the graphic on the top, you might be able to tell that the lots right adjacent to the airport boundary are not available. This one happens to be right off Centennial Road.
Okay, thank you. I knew there was a distance, but I wasn't sure how much, if any, of our park it included. So it does include some of the park. Okay,
Well, if we
thank
don't
you.
do it right, Cheech and Chung are going to handle the reservations in the Holiday Inn.
Possible.
Brett, on the 6 plants per individual, has the state set guidelines of where you can and cannot grow that yet?
Only through the proposition, and they're gonna have a hard time dealing with where you can and can't grow that. We're not allowed to zone it and say you can't do it in,
Front yard.
residential, or you can't do it in an apartment. They're allowed to grow that. What the proposition says, it must be in a facility that is secured from minors and not basically visible to the public from the naked eye. And so it's going to be, when you adopt an initiative like this that the voters did, we have a provision called the Voter Protection Act that really stops the state from enacting regulations that would pull back on that. That happened for a number of years ago after initiatives were passed and the state essentially gutted them because the legislature didn't believe in it or the council didn't believe in it. So they're really going to be hard pressed to put a lot of regulations in because you're not going to have to ask permission to do that. You can grow as of right without asking for any permission from the city, from our zoning or otherwise. So it's going to need to be in like a closet, a greenhouse, other security that they can secure. But other than that, there's not going to really be any regulations. If they violate them, the first violation is also a petty offense.
Are you done?
If you don't have any questions, I'm done.
Anybody have any other questions?
Just a comment, if I can, for the mayor and the city council. We've heard this evening about the potential of an amendment to the proposed ordinance related to violations. Are there other elements that the council's interested in providing some guidance?
I forgot to ask about delivery, because we had this question last time, and delivery, I think, would solve some people's problems too, because then you wouldn't have a place, it just goes.
So two things on the delivery, and I'm glad you mentioned. I said I was done because I didn't want to talk anymore, but I didn't go over the delivery
Here
section.
I am making you work, Brad.
No, I didn't go over the delivery section. We've put delivery in prohibited right now because the statute allows us to do that. We're going to have plenty of time in reviewing those regulations because under the proposition, the department can't allow delivery until 2023.
Okay.
But they must allow delivery by 2025. So the main reason that we put delivery in was to try to make sure that nobody tries to do an Uber Smokes here where they say, I'll go get it for you. It would violate the department's regulations, but that's going to be a more difficult thing for us to address. There's actually a severe civil penalty if a marijuana establishment tries to deliver without getting the rules first. But since there's not really anything else, we can kind of stop that. What you cannot prohibit under the act, though, as I say this for delivery, this is really delivery for a fee. Because what you cannot stop under the act is people transferring 1 ounce or less of marijuana, as long as it's not for remuneration. So if you're not getting paid to do it, you can pick some up and deliver it to your house, right? Or to a friend that isn't able to go out. You just can't make money off of doing it.
And the other thing I can't remember in the ordinance, but is the recreational, so they have the testing sites now, because is the recreational limited different than the medical as far as potency, I've heard?
Yeah,
Is that
I
true?
think, and I don't know the actual,
but it's
the actual medical
different, right?
pieces, but it is, with respect to edibles, there is a limit on what the potency is, how you measure that. I think it's 10 milligrams per separated dose, and the container can't have more than 100. So it is going to be a little bit different than what you can do. It's also different, and it's a good point, the Medical Marijuana Act, a lot of people have said it goes away once you do recreational. It doesn't. It actually is still in place, and it can make a difference for some individuals because, for example, if you are still a medical card holder, you can have up to 2.5 ounces of marijuana versus someone that only has 1. You can, if you are a caregiver that's allowed to grow, we don't have any, you can grow 12 plants per person that you give care for. So they can have up to 72 in their home. We don't have any of those. That's why we wanted a dispensary in the first place, was to stop that. But the medical marijuana doesn't go away, which is why in our delivery section, we say, hey, if the ADHS allows for medical delivery, we are going to allow it as well, because we weren't allowed under the Medical Act to stop things like that.
And is
Brett,
it,
how do the people that are cultivating it, how do they market it?
I don't know what they normally do, but ordinarily under the rules, they need to already have buyers for it.
They have to have a
Arizona's
dispensary.
not licensing currently
Be licensed?
anyone to grow for out of state. So they're growing only for dispensaries, and each dispensary is allowed to have, or needs to have a designated grower essentially. So some of the cultivation facilities, and I would let Mr. Tice answer to this because he's dealt with them more, but some of them may come in and say, we're growing for harvest, and it's going to be for these 4 facilities, for example. But it's going to be for that. They have to have a specific dispensary to get a cultivation license. So you can't just get a license right now from ADHS to just grow and sell it to whomever you want.
and what is the tax then?
So there's a kind of a convoluted piece, but the surcharge is about 16%. So it's subject to your normal retail taxes, which were at what, 9.8?
9.2.
9.2. So it's subject to all of our retail sales taxes. We cannot raise it on marijuana. We can raise all of our sales taxes, but we have to float all boats the same. We can't tax that more.
Right.
It's subject to a surcharge of, I think, 16%. There's also a provision, though, that makes that, if the federal government starts decriminalizing it and taxing it, that caps the tax rate at 30% overall. And that money goes into a designated fund that goes to a number of different things, but the city will actually see some of that fund because it goes towards, her funding is getting some of it. Police, fire, medical, based on how many people you have in PSPRS statewide, will get some of that as well. No one knows what those numbers will be yet.
But medical is not subject to that then, right?
Right,
Just
medical is different, you're not subject to the tax, and you don't see any of those. And that's why I say, there's still gonna be 2 regimes. There's still gonna be medical and non-medical.
When you say no one knows, there's got to be some type of research where in other states where they had just a medical and then went to a,
Colorado,
yeah.
Nevada.
There are
any way
numbers
to
in-
estimate that at all?
I think we could guess, and I think
Yeah.
the state sort of looked at it, but the problem is you just don't know what your market is until you see what your market
Yeah.
is. And each one is gonna be a little bit different. So, right, because everyone's taxing
Yeah.
it differently. Colorado saw it go up like 300 million, I think, in a year, and California was close to the same, but California's got a lot more people, so it just goes to show you, you really don't know until you start to
Do
put
they
it
pay the
in.
regular sales tax at an Arizona rate when they sell it?
Yes,
And for retail, yes, not for medical.
not for medical.
Medical's not taxed, right?
Any other questions? Anybody?
No, but Brett, I appreciate the information that your staff has done, and, you know, it's kind of a no-win situation without having the rules yet from ADHS, so it's kind of disconcerting in that regard, but I think this is our best option at this point. Oh.
Yeah, if anybody, does anybody have any issue with Lisa's suggestion on those changes?
I think that's great.
No, that's a good point.
Can we make those changes then before we hear it tonight?
Absolutely.
Okay. All right.
We're running very short on time, but just one clarifying point, well, I shouldn't say clarifying point, but additional point for the community that may be watching us. The zoning ordinances, as Mr. Wallace has pointed out, obviously has a completely different process than the ordinance that we're proposing tonight under our health and safety. It has to go to the Planning and Zoning Commission, have public hearings and the like. This particular ordinance is under health and safety, and given the timing of this, staff will, at the second read, be encouraging the council to pass it with an emergency clause so that it would become effective at that moment. But again, we will outline that again during the regular meeting.
Okay. No other questions, then we'll stand adjourned on the study session, and you got a minute.
One more